Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 191. I did promise I'd be doing the next one a little bit more speedily than the gap between the second last and the last one, so I've followed through on that. Again, we're doing just two cases as I wanted to go into the first one in a bit more depth as I think it justifies it, but by way of payoff, I think the two cases I'm doing this episode are probably the most widely contrasting cases I've done in a single podcast episode. The first case is obviously important and relates to the issue of justification for indirect discrimination. In particular, it looks at whether or not it is true that there is a cost-plus rule for an employer who is looking to justify discriminatory measures for financial reasons. The second case, by contrast, well, it's a bit of a soap opera, but deals with a contested unfair dismissal claim on whether or not the claimant was constructively dismissed. No cultural reviews this week, unless I sneak in a reference to the fact that I'm no Star Wars fan, but I'm thoroughly enjoying The Mandalorian. But that may be as much because I'm sitting watching it with my elder son, and it's nice to spend time with him. Anyway, please don't forget, obviously, podcasts available, iTunes, the Mayor Brown website, YouTube, Twitter feed, Spotify, Google Play, Yahoo, all good booksellers, to the extent that they're open at the moment, etc. So, first case, Heskett and Secretary of State for Justice. This is a Court of Appeal decision dealing with a claim for unlawful discrimination by Mr Heskett on the grounds of age. He was complaining about indirect age discrimination connected with his pay. Facts in this case, well, they weren't really in dispute, but in essence, Mr Heskett worked for NOMS, which was the probation service, the National Offender Management Service. At the relevant time, the annual budget for NOMS was set by the Ministry of Justice. Once the budget had been set, it was then up to NOMS to set the pay for its employees. So any employee, in effect, was subject to constraints imposed by the Treasury. Before 2010, NOMS had a pay progression policy. Jobs were placed in a pay band. There were a number of spinal points in each pay band, and employees would progress up the pay band by a set number of points each year. Pre-2010, individuals were entitled to go up 3 spinal points in the pay band each year. The pay band that the claimant joined in 2008 had 25 spinal points, and so he'd reached the top of the band under the old system in 8 to 9 years. However, in June 2010, as part of the austerity drive, the government announced a pay freeze on the public sector, limiting pay increases to a maximum of 1% of overall pay costs. NOMS went into negotiations with its recognised unions. As a result of those negotiations, an altered pay system was put in place. The pay bands remained, as did the number of spinal points, but individuals could only progress at the rate of 1 spinal point per year rather than 3. The claimant calculated, bearing in mind he'd been in his pay band for a couple of years when this was introduced, that instead of having to wait for a total of 8 to 9 years to get to the top of the pay band, it was going to take him something like 23 years. The claimant pointed out, and I think in fairness I should add, it wasn't really disputed by the employer, that this change disproportionately affected younger employees, which included the claimant. Obviously, if you're higher up the pay band when the rates of progression drop from 3 spinal points to 1, you're effectively starting from a higher base, and it'll take other employees who have joined since then longer to get to the point where you are starting from. The court therefore had to decide whether or not the pay system was indirectly discriminatory on the grounds of age, and definition for indirect discrimination is of course contained in Section 19 of the Equality Act, and under Section 19.1, a person, A, discriminates against another, B, if A applies to B a provision, criterion or practice which is discriminatory in relation to a relevant protected characteristic of B's. It's then necessary to show that the provision, criterion or practice, the PCP, puts B at a particular disadvantage because of the protected characteristic, and A cannot show its proportionate means of achieving a legitimate aim. So the court here is looking at two things. Was the PCP, which we'll come to in a moment, seeking to achieve a legitimate aim? And if so, was it a proportionate means of achieving that aim? The legitimate aim, of course, is a matter for the employer's choice. Whether or not it is a proportionate means of achieving that aim is, of course, for the tribunal to determine. But, of course, the tribunal can determine that a legitimate aim is in fact not a legitimate aim. But it's up for the employer to put forward what it considers to be the legitimate aim. So, the PCP here was the reduction in the rate of pay progression from 3 spinal points to 1. The only relevant justification put forward by the respondent was the significant reduction of public money that was available to it in the light of the significant downturn in the economic climate in 2010. The claimant's case was that since the principal driver for the revised pay policy was the saving of costs, that didn't pass first base. It could not be a legitimate aim, and therefore the claim had to fail. The claimant's claim had to succeed, the defence had to fail. It wasn't, in the claimant's view, it wasn't necessary to go on to consider whether what the employer was doing was a proportionate means of achieving a legitimate aim, because it just didn't pass the test for being a legitimate aim. Claimant pointed to various cases that had distinguished between a costs-only aim, which was never legitimate for an employer, and the so-called cost-plus approach, where employer was relying on costs savings in addition to something else as a potentially legitimate aim. Here, the claimant said the reduction was clearly about saving costs, and therefore it couldn't be legitimate. I win. The Employment Tribunal disagreed. They acknowledged that central government might have had an objective of saving costs by issuing a pay cap, but the position for NOMS was more nuanced. It had to live within its means. The measures it adopted were a means of doing so. This meant, therefore, that the employer was not relying on costs alone to justify its discriminatory conduct. It went on to decide that the policy was a proportionate means of achieving that legitimate aim. Crucially, and I'm going to come back to this in a second, part of the rationale was that the respondent was aware that progression through the spinal points was going to be painfully slow. It, too, wanted to change the system it had put in place in 2010 and was doing what it could to come up with a more equitable arrangement in the longer term. And the tribunal took into account the fact, in deciding that there was a legitimate purpose, that it was defensible, that NOMS was intent on taking steps to change the potentially discriminatory PCP, in accepting that when it accepted that the measures it was being asked to evaluate were a proportionate means as a short-term measure of achieving a legitimate aim. I would add, the short-term measure had been going on for 6 years by the time the Employment Tribunal was hearing the case, so it's obviously a term which has a degree of flexibility built into it. The EAT upheld the Employment Tribunal in the case, and so the case went up to the Court of Appeal. Although there were 3 grounds of appeal, I'm just going to focus on 2 of them. First, since the Employment Tribunal had drawn a distinction between cost, which they said could not be a legitimate aim, and an absence of means, caused by central government, which could be a legitimate aim, the claimant argued that the tribunal decision on this point was wrong. It was a distinction without a difference. Secondly, the appeal ground contended it was wrong for the Employment Tribunal to believe that, because there was active consideration being given to changing the temporary pay policy, that fed into the justification of that temporary pay policy as being a proportionate means of achieving a legitimate aim. In response, the Court of Appeal states, the Secretary of State argued that there was no reason in principle limiting cost-based justifications from the scope of a potential legitimate aim. It was not necessary to have cost-plus factors. A cost factor on its own could potentially be legitimate. The Court of Appeal gave a lengthy, very thorough summary of the case law in relation to the cost-plus cases and where the courts have had to consider the impact of financial issues and cost issues in relation to justification. Court of Appeal's conclusion is that the case law from the European Court means that saving or avoidance of costs does not, without more, amount to the achieving of a legitimate aim. To take the classic simple example, an employer cannot justify a discriminatory payment to A being less than B simply because more money to pay A the same. Goes without saying. But converting that into a general principle, the Court of Appeal say that the essential question is whether the employer's aim, in acting in the way that gives rise to the discriminatory impact, can fairly be described as no more than a wish to save costs. If it is no more than a wish to save costs, then the discriminatory aim is not a legitimate aim. If it is not merely a wish to save costs, then it will be necessary to look at a fair characterisation of the employer's aim taken as a whole, and then to decide whether that aim is legitimate. The Court of Appeal referred back to the Woodcock case, where, if you remember, an individual is going to be in line to achieve windfall benefits under a pension scheme if allowed to go beyond his 50th birthday, since the benefits the individual would have been entitled to were not ones he had a legitimate entitlement to expect. It was not a cost case, it was a cost plus case. I'm using the term cost plus, although the Court of Appeal clearly disliked the term, and preferred to refer to the test as being whether or not the employer's aim is solely to avoid costs. Maybe I can coin an employment term. If cost plus is out, maybe we will be allowed cost solely instead. I doubt it'll catch on. Anyway, it's only if the fair characterisation of the aim is that it is indeed solely to avoid increased costs that it has to be treated as not being a legitimate aim from the get-go. Looking at the facts of this case, therefore, the Court of Appeal agreed that the employer's desire to live within its means was a legitimate aim. The Court of Appeal said they could, quote, see no principal basis for ignoring the constraints under which an employer is in fact having to operate, unquote. This sentence, the Court of Appeal points out, switches the focus to the justification defence. The employer has to show that measures complained of were a proportionate means of achieving a legitimate aim, looking at the disparate impacts of the particular group in question. The tribunal will look at both the nature and extent of the financial pressures which the employer relies on, as well as whether there were any less discriminatory alternatives which would have avoided or reduced the discriminatory effect that is now being challenged. Turning now to the issue of whether or not the temporary nature of the 2010 pay arrangements was a relevant factor, the Court of Appeal agreed with the Employment Tribunal. They said it was. The Court of Appeal could see no reason, quote, why in principle it should not be open to the employer to seek to justify those measures on the basis they represent a proportionate short-term means of responding to the problem in question, albeit they could not be justified in the longer term, unquote. So, the employer wins the case. You can understand the claimant perhaps feeling somewhat aggrieved, since the government was setting the pay freeze, but the employer, NOMS, was the one implementing it. There was no direct linkage between the government's desire to save costs and NOMS' necessary desire to live within its means and adopt a short-term measure to enable it to do precisely that. But I do think the great measure of this case is it's entirely logical. I also think it means that by characterising the issue as to whether or not the aim was quote, solely about saving costs, unquote, the Court of Appeal has made it much more difficult for employers' aim to be ruled as illegitimate without any consideration of whether it is proportionate. Conversely, by requiring tribunals to go through a diligent process of analysing whether the steps taken were a proportionate means of achieving a legitimate objective, the Court of Appeal is really firing a warning shot. Employers are going to have to explain to a tribunal what alternatives were considered, why these would have been less effective as a way of achieving the particular savings with any other additional justifications that are being relied on. Seems to be anticipated here, for example, it wasn't open to NOMS to make redundancies to achieve the necessary savings. If a similar case again arose in the private sector, you would at very least be expecting the employer to lead evidence as to how it had considered redundancies or other cost-saving projects and why those would have been insufficient to achieve the legitimate aim. So I think it's going to be an important case. We're going to come back to this case again and again. I don't know whether it's going to be appealed. It'll be very interesting to see if it does go further. But it obviously goes to the heart of how tribunals, courts, should approach the issue of justification where cost savings are an issue. Chem at Scotland Limited and Mrs. Ure. This case, as what was the one I described at the start of the podcast as being a bit of a soap opera, it certainly made the Scottish daily newspapers happy for a while, because in essence it was a pretty bitter father-mother-daughter battle being fought through the Employment Tribunal. Legal issues were that the claimant declined to come back to work after the end of her maternity leave, although she failed to write to the company to communicate that she was treating her departure as a constructive dismissal. The Employment Tribunal took the view that the failure to return to work itself constituted the communication that she was treating herself as constructively dismissed. The Employment Tribunal also had to look at what was the constructive dismissal based on, and was it necessary for the employee to tell the employer they were treating themselves as constructively dismissed for the right reasons. Background was that the claimant was the daughter of the majority shareholder in the company. Claimant and her father fell out, apparently spectacularly, after the claimant's father had left his wife, her mother, and formed a new relationship with a member of staff at the company. The divorce was ongoing at the time. The claimant pointed at the tribunal case to a number of breaches of contract which occurred during her maternity leave and said that these amounted to constructive dismissal and that by not returning to work she'd accepted them. The definition of constructive dismissal is set out in Section 95 of the Employment Rights Act. An employee is treated as dismissed if the employee terminates the contract under which he, or she I should say, is employed in circumstances in which he or she is entitled to terminate it without notice by reason of the employer's conduct. I point out it doesn't say in that definition the employee has to notify the employer of that assertion and the basis for it. Well, in this case, it was determined at a preliminary hearing that the claimant's employment ended on 25th September 2017, which was the date she was due to come back to work after her maternity leave. As I say, the Employment Tribunal then subsequently found in favour of the claimant, and the appeal to the EAT was on two bases. First, the claimant's emails to the company subsequently made it clear that she was resigning, she said, because her statutory maternity pay had come to an end. As a point of legal fact, the SMP had come to an end on the correct date. There was no obligation on the company to continue it, and therefore the company said that this action could not amount to a breach of contract sufficient to found a constructive dismissal claim. Secondly, the company asserted that because the claimant had actually failed to communicate at the time, or to formally accept the repudiatory acts ending the contract of employment, that could not amount to a constructive dismissal. The Employment Tribunal said that it was correct that the claimant had referred subsequently to the failure to continue paying the SMP, and moreover that the company was right to stop the SMP. So that did not give rise to the constructive dismissal. However, the EAT said that the tribunal had been entitled to take into account the factors that in its judgment were relevant to the decision by the claimant to end her employment. There were multiple other breaches which had occurred. She was swapped from one company to another without warning. There was a failure to pay her money that she was due on time. She had raised reasonable queries, which were completely disregarded by her employer. In the circumstances, the Employment Tribunal had been entitled to find, the EAT said, that she'd been constructively dismissed for these factors, despite the fact that shortly afterwards she'd given a different reason in writing for her complaints. The EAT then turned to the issue as to whether or not it was necessary for the claimant to have communicated acceptance of the repudiatory breaches. The court accepted that in normal circumstances merely failing to come back to work might not amount to an acceptance through repudiation. However, depending on the circumstances, they said, it could clearly amount to an adequate communication of intention no longer to carry on working for the company, and so the tribunal was entitled to find that as a fact if it chose to do so. On that basis, the EAT did not feel able to interfere with the tribunal's finding of fact, and accept that her non-return did amount to a sufficient communication that she was terminating her employment. I think it has to be, had scarcely helped the company's case that when she didn't return to work on 25th September 2017, no one from the company got in touch with her to ask her where she was. In other words, seems to be a legitimate inference that the company knew full well that she was quitting her job. As the EAT put it, quote, the claimant did not need to communicate with the respondent. The respondent was hoping and perhaps even expecting her not to return. Unquote, stop. So clearly this is an extreme set of facts. However, we've had a number of occasions we've had to advise clients where employees have gone missing. It tends to happen with periods of illness. What happens when an employee goes off sick pay runs out, and then they just disappear? In those circumstances, it's often very difficult to know for an employer whether they're better off terminating the contract, even if it may be difficult to give notice to the person concerned because they can't be tracked down, or simply to assume that the contract has ended. If someone then pops up down the road claiming constructive dismissal, what's the evidence that they were accepting a breach by just not getting in touch? Obviously, the point about notice, whether or not you can give notice, can be rectified if you've a deemed service clause in your contract of employment. At least that'll bring the contract itself to an end. But I was advising last year in one case where an individual went missing having gone off sick after alleging sexual harassment at work. The suspicion was that she'd gone to another country in circumstances which were very unclear, and the company simply did not hear from her again. In those circumstances, I think it would be much more debatable whether simply absenting yourself from work after a period of illness was acceptance of an alleged repudiatory breach. Anyway, the point, as always, is that the tribunal here was entitled to look at the facts and say that in these circumstances it was clear what was going on, and therefore the employee was not going to be deprived of a constructive dismissal claim merely because she hadn't expressly said, I'm ending the contract because of the way I've been treated. So, those are the two cases for us today. Thank you very much for listening, as always. Thank you for the nice comments online. Those are very much appreciated. We will probably be doing another podcast in a week or so's time. There seems to be a fair amount coming through, so let's surf the wave and keep up the podcasts at the current rate of progress. Anyway, until next time, I hope everyone stays safe and out of harm's way, and that no one's doing any inappropriate mingling out there. Until podcast number 192, take care, everyone. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.